Let us continue reading this reconveyance case. Taas-taas dyan. Now, ang topic na to is about the claim by spouses aboites that the title of the adverse party is fake and fraudulent. Pasensya ay akong tingog ha, kay murag nataptan ta sa flu. The spouses aboites posit that the deed of absolute sale between Siriaco and the spouses po is fake and fraudulent. They argue that that this is evidenced by certifications of the document's non-existence in the notarial books and the spouse's failure to enforce their rights over the property until 18 years later. They also claim that the deed of absolute sale is inadmissible as no documentary stamp was paid and affixed. This court notes that the spouses aboites are raising questions of fact which are not within the scope of a review on certiorari under Rule 45 of the Rules of Court. An appeal under Rule 45 must raise only questions of law. So, i-address ni sa Honorable Supreme Court kaning issues nga ilang gi-raise more on the scope of Rule 45 that they are asking the Honorable Supreme Court to resolve issues which are beyond the scope of their chosen remedy, which is Rule 45, review on certiorari. An appeal under Rule 45 must raise only questions of law unless the factual findings are not supported by evidence or the judgment is based on a misapprehension of facts. So, mo na exception. As a general rule, raise only questions of law. Exception, the factual findings are not supported by evidence or the judgment is based on a misapprehension of facts. Absent these exceptions, the factual findings of the lower courts are accorded respect and are beyond the review of this Honorable Supreme Court. The spouses aboites fail to prove that these exceptions exist in the case at bar. The regional trial court lent credence to documents presented by the spouses po. Peter's testimony about Mariano's sale of the property to Siriaco, Siriaco's sale of the property to the spouses po, and the issuance of a tax declaration in the name of Victoria. During trial, Peter also testified that after they bought the land, they had a caretaker who cultivated the property by planting fruit trees. He claimed that when they subsequently discovered the quitclaim executed by Siriaco in favor of the spouses aboites, they executed a memorandum of agreement to protect their interests in the property. He stated that they filed a complaint in the barangay when the spouses aboites started cutting down their improvements, and that they subsequently discovered that Siriaco was forced by the Mariano heirs to sell the property to the spouses aboites. Spouses aboites presented as their first witness Armando, who testified according to the records only. So, maura to yung scope sa iyang testimony. He claimed that he was familiar with the land which was being developed by aboites land. He testified that Roberto acquired the land through separate deeds of sale from the Mariano heirs, had the tax declaration transferred in his name, paid the taxes on the property, applied for the property's registration, and developed the property into a subdivision. During cross-examination, it was revealed that the tax declaration of the spouses po was issued before the tax declaration of the spouses aboites, and that the spouses po acquired from Siriaco the entire land, which the spouses aboites purchased only 1/5 of the property. Spouses aboites' second witness, Bienvenido, testified that he was a masonry worker siguro, working in the subdivision on the road lot, and that he knew no person claiming ownership of the land since 1989. The regional trial court thus held, analyzing the adduced and admitted evidence of both parties, Article 1544 of the Civil Code cannot be aptly applied in the case at bar for the reason that only the sale of Seriaco has the validating elements of sale, whereas the rest of the deeds of sale executed by the heirs of Mariano in favor of the defendants are void for containing untruthful statements as pleaded and proven. They are no longer the owners of the subject property when they executed the several deeds of conveyance to defendant Roberto. On the first issue, on the identity and location of the land, the sale of Seriaco to plaintiffs reflected in the tax declarations that the defendants used in their titling proceeding is the very same lot as certified by the barangay captain under the plaintiff's request for admission. Concerning the second formulated issue, only the deed of sale executed by Seriaco was valid with all the attending requisites of sale. It was sold by the legitimate owner of the land, Seriaco, to the plaintiffs. The sale enjoyed preferential date of execution, being dated or executed in 1978 by the lawful owner, Seriaco, who was first to register the sale in the Registry of Property. And due to such registration, the tax declaration of Seriaco was cancelled and a new tax declaration was issued in the name of Victoria Po, as shown in the exhibits. The said tax declaration succeeded in cancelling. Okay, na-cancel niya ang tax declaration of Mariano and was issued thereafter a tax declaration in the name of Seriaco. So when the latter sold the subject land to plaintiffs in 1978, the same was already owned by Seriaco. When Mariano died, the subject land owned by Seriaco naturally is not part of the estate of Mariano. For at that point in time, the subject land is now owned by the plaintiff's spouses po, and the same was declared in their names. No? Excluded from the estate, nabaligya naman. As to the issue whether the defendant Roberto was a purchaser in good faith and for value, the court holds that the defendant Roberto was not a purchaser in good faith and for value, for he was already informed of the ownership of plaintiffs over the subject land during the conciliation proceedings before the barangay official when plaintiffs filed a barangay case against him. In this case, the court believes that the defendant Roberto is aware of the proprietary rights of the plaintiffs, considering the land was already declared for taxation purposes in plaintiffs' names after the tax declaration of said land. So, pagkahuman adto, no, ang yuta na deklara na siya for taxation purposes, meaning sa deklarasyon pangalan na sa plaintiffs ang nabutang, no, was already declared for taxation purposes in the plaintiff's name after the tax declaration of said land first in the name of Mariano was cancelled. So pag cancel ka Mariano, nabalhin na siya sa deklarasyon ang pangalan sa deklarasyon dito na sa name sa plaintiffs. So nanay conveyance, no? And another one issued in the name of Seriaco when the latter brought the said land from his father Mariano. And after the said tax declaration in the name of Seriaco was cancelled, and another one issued in the name of plaintiffs herein. So defendant Roberto purchased the subject land from the heirs of Mariano who are no longer the owners thereof. No? Nabaligya naman siya seller. And the tax declaration of subject land was no longer in the name of Mariano nor in the name of heirs of Mariano. The city assessor of Mandaue even issued a certification to the effect that tax declaration in the name of Po married to so basically the tax declaration under the name of spouses Po was issued prior to the issuance of the tax declaration in the name of Roberto. Ay chata, kadiyot lang kayo. Lang kayo. Namutana ang say sudan para panihapon. Tiwason sa ato kay magluto ko. Buyers of any untitled parcel of land, for that matter, to protect their interest. Diba? Lubati sa kulo eh. To protect their interest will verify from the assessor's office that status of said land, whether it has clean title or not. So with the exception of its ruling regarding respondents Jose, Ernesto, and Isabel being purchasers in good faith, these factual findings were affirmed by the Court of Appeals. Thus, there is no showing that the factual findings are not supported by evidence or that the judgment seems to be based on a misapprehension of facts. Therefore, the factual findings of the lower courts are binding. Basically, the factual findings of the lower courts are binding as a general rule unless musud tong mga exceptions nga itong gi-mention. Sorry. Na yung mga chat. Furthermore, this court finds that the spouses aboitis failed to prove their claim of fraud. The spouses aboitis ano man attempted to prove that the deed of absolute sale between Siriaco and the spouses po was fake and fraudulent by presenting certifications of its non-existence in the notarial books of the notary public who notarized the document. However, a review of the certification does not even state that the document does not exist in the notarial books. So, gi-scrutinize ang certification niya gibutang ra ngadto nga certified that the said notary public has not submitted these notarial reports dito sa notarial division, no? These certifications do not declare that the deed of absolute sale does not exist. They only state that at the time of their issuance, the notary public had not submitted these notarial reports or that the document had not been transferred to the archives for safekeeping. It cannot logically be concluded from these certifications that the document is inexistent, false, or fraudulent. Kaya ang certify nga to, wala ra masubmit daw or wala pa maabot sa ilaha ang records, wa pa ma-transmit or wa pa masabit sa notary public. Basically, di siya clear nga certification nga wa mo exist ang document, no? Lahi man ang kung moingon tag wala mo exist ang document, pwede misla mo certify nga based on records, makita diri during that time ani doc number, page number, wala ni nga document aw kana lahi na storya. Pero kung gi-certify lang at the time of the issuance the notary public had not submitted these notarial reports or that the document had not been transferred to the archives for safekeeping, di sila ka-certify nga naa or wala, no? Whether ni-exist or wala. Kay ang ilang gi-certify wa pa man masubmit ang notarial records or wala ma-transfer sa archives. So, sakto pod, no? You cannot assume nga abi kay mo to gi-certify automatic it would mean nga wala mo exist ang document. Kay basin gyud og nagpanotaryo na present ang mga signatories ni pirma ginotaryuhan nya sala lang sa notary public wa taga-sulti nga mo na nahitabo diri ha. Pero na may times nga notary public di makasubmit, luoy po tong party sa sale kung automatic imong i-treat as if wala mo exist ang deed of sale, di ba? Rule 132 Section 30 of the Rules of Court provides that Section 30, Proof of Notarial Documents. Every instrument duly acknowledged or proved and certified as provided by law may be presented in evidence without further proof, the certificate of acknowledgement being prima facie evidence of the execution of the instrument or document involved. So basically, mag-submit gyud ka og dokumento sa korte, mo na advantage, no? Naa siya ay evidence of the execution basically na siya presumption nga ang document was duly executed. Pasabot kanang ni pirma des dokumento dili forgery ang pirma. Pag pirma sa signatories diya sa dokumento, wala siya gitutukan og pusil, no? Wala siya gi-threaten o unlawfully threatened, no? Na may threaten nga di kay kamo ariglo kihaon ta ka o kana lahi na siya. Pero kanang threat mga pirma sa deed of sale or else di na nimo makita nimong anak, yung anak nga type of threat, no? Unlawful threat. So kung notarized ang document medyo presume siya nga ang signature diha dili fake kay ni certify notary public ana nga sa iyang atubangan ni anha na ang signatory sila ni pirma or gi-acknowledge niya sa tubangan sa notary public nga iyahan ang pirma iyang gi-acknowledge sa atubangan sa notary public nga nakasabot siya sa suwat sa sulod anong dokumento ha og voluntaryo niya nang gipirmahan walay gi-hostage wala siya gitiunan og pusil mo nay presumption makuha nimo kung notaryado ang dokumento. To overturn the presumption in favor of a notarized document, the party questioning it must present clear, convincing, and more than merely preponderant evidence. So, naman na ko'y kitawag na to nga morabag levels nga kailangan nimo sa na to pa-explain ha sayon sabton quantum of evidence. Morabag na-level ba nga kailangan nimo ma-satisfy para nailain nga morabag grade 1, grade 2, grade 3 na-level ang ebidensya nga kailangan nimo nga ma-satisfy no sakto ba no so naay level nga preponderance of evidence lang naay level nga clear and convincing evidence mo na gitawag na to nga quantum of evidence no nakay sukdanan ba nga kailangan makaabot diha imong ebidensya para mo baliktad ang katong presumption no kaya ang presumption maskin way proof mo barog ng iyaha kung against nimo ang presumption sa kaso kailangan ka mo hatag anang level of evidence required under the rules para katong presumption mo baliktad para siya nga pikas siya na po'y mo prove para mabuhi gito iyahang presumption no para iyang kumbaga murag katong presumption na natumba naman kailangan na pod mo move forward siya with evidence para ma-ruled na pod in favor sa iyaha ang katong question of fact. No? Thus, parties who appear before notary public should not be prejudiced by the failure of the notary public to follow rules imposed by the notarial law. Mao ni akong pasabot no. Ikaw niadto ka sa tignotaryo, nibayad ka. Gidani mo ang signatories, seller, buyer, witnesses. Perfect tanan, may pagkabuat tanan. Pag uli nimo sus wa man makasabit si notary public sa iyang notarial report or wa niya ma-appeal og submit ang kopya sa imong dokumento dito sa iyang notarial report kay iyang sekretary na sipyat di po na sa gapanotaryo di ba luoy sa kayo o kita na storya masuko ka although nindot gyud unta to kung na-submit di ba kay the moment nga moadto sa notarial division or sa archives makakuha kag kopya sa imong gipanotaryohan and makita nimo dito sa libro. The spouses aboitiz failed to present clear and convincing evidence to overturn the presumption. The notarized deed of absolute sale between Siriaco and the spouses po is thus presumed regular and authentic. Consequently, this court can affirm the finding that the property was sold to Siriaco in 1973 and that Siriaco, as the owner of the property, had the right to sell it to the spouses po. Hence, the lot did not form part of the estate of Mariano, and the Mariano heirs did not have the capacity to sell the property to spouses aboitiz later on. Tungod kinabaligya na ang property, no, na-excluded na to. So pagkamatay sa decedent, di na to part yung estate, nabaligya man niya during his lifetime. So ang heredero, di na to siya kabaligya, kay di naman to appeal sa iyang inheritance. Okay? So napatay usa ka issue diri, indispensable parties nga issue. Sunod na lang ni guys kay magluto sa kog panihapon. Alas 8 na, gutom na kaayo. I'll see you in the next video.